Today we're going to talk about Chapter 12, which covers the legal response to child abuse and neglect. Courts become involved with families if the child is in imminent danger or if the parent's unable or unwilling to cooperate with protective services, or if the parents are hospitalized, incarcerated, or physically or mentally incapacitated, if a child has been abandoned, or if a court order is needed for the child to receive medical treatment, or if the child is severely injured, sexually abused, or murdered by a parent. Parents have the right to be notified if they are suspected of child abuse. They have the right to an attorney, which is most often provided by the state. They have the right to a hearing, the right to confront accusers and cross-examine. They also can demand specifics of allegations from individuals who are making the complaint. Children's rights are less clear than their parents. They are assigned an attorney, also called a guardian ad litem. They have the right to a hearing before removal when it's possible and safe, and they have a right to a family life. Native American children are protected by the Indian Child Welfare Act of 1978. Prior to 1978, many Native American children were removed from their communities and placed with white families, and the Indian Child Welfare Act gives decision-making power to the tribes. Child welfare cases usually only go to criminal court in cases of extreme abuse or abuse outside of the family. A victim witness advocate can offer support and prepare the child for court. The outcome of criminal cases are usually either dismissal, fines, which are unusual, jail time, or mandated treatment. Some research has discovered that the court process is not necessarily unduly traumatizing for children. If children have strong maternal or familial support, this can mitigate some of the trauma. Older children most often have more difficulty than younger children, and that's likely because they are more aware of what's going on. Long court battles can be more difficult on children, and some helpful ways to prevent trauma for children is psychoeducation, stress management techniques, guiding parents and supporting the children, and individualizing interventions to the child's needs. In 1994, Megan Kanka was 7 years old and from New Jersey. She was raped and murdered by a convicted sex offender, and the community was unaware of his past. So Megan's mother fought for community notification of sexual offenders, and which ultimately resulted in Megan's Law and was signed into law on May 17, 1996. Megan's Law enables the public to learn of high-risk offenders through local police and sex offender registries. A study in New Jersey found no subsequent reduction in victims after Megan's Law was enacted, and there's some that argue that it makes it difficult for offenders to try to repair their lives and move on. Later, the Adam Walsh Child Protection and Safety Act expanded Megan's Law and required sex offenders to register and creates tiers of offense.